Welcome to a brand new episode of Law and Batting Order. I'm your host, Tony Iliakostas. Here are some quick hits from the past 2 weeks. While the last days of the 2012-2013 college basketball season are winding down, a major conference change has been made that will change the look of the NCAA basketball season next season. On Friday, the Big East Conference announced that it has allowed 7 of its schools to depart the Big East in an attempt to create their own league called the Catholic Seven. The Catholic Seven, which weirdly consists of 10 teams, will include Butler University, St. John's University, Georgetown, Seton Hall, and Marquette, among other schools. The assembly of the Catholic Seven is expected to begin the domino effect of conference realignment in college basketball. First, MLB and the MLB Players Association agreed to begin in-season HGH testing, and now it appears that the NBA will be the next major sports league to begin HGH testing during the season. The NBA and the National Basketball Players Association are close to an agreement that will implement an HGH testing program during the season. Testing could begin as soon as the 2013-2014 season. Plans of implementing an HGH testing program were first introduced when the NBA CBA was negotiated in 2011. Conditions were left out as both the owners and the Players Association didn't see eye to eye, although it appears that both sides are open to improving the quality of the NBA. Mariano Rivera, who has been the Yankees closer for nearly 2 decades and single-handedly the best closer baseball has ever seen, will be retiring at the conclusion of the 2013 Major League Baseball season. Mariano missed a majority of the 2012 season due to a leg injury he sustained while shagging fly balls during batting practice. However, Mariano is determined to get back on the field and be his old self before hanging up his cleats. In his 18-year career, Mariano holds the Major League record for the most saves by a closer with 608 saves and counting, and has won the World Series 5 times. Here at Law and Batting Order, we're happy to see Mo back in pinstripes and wish him a very successful 2013 season. Today's Order in the Court will be discussing employment discrimination in the NFL. We're about a month and a half away from the NFL draft, and a player's draft stock is based largely on how a prospective NFL player performs at the NFL Combine. From 40-yard dashes to basic vertical jump tests, college athletes entering the draft show off what they have to offer to NFL scouts in an attempt to be drafted and ultimately sign with a team. In addition to physical performances, college athletes have an opportunity to sit down with NFL team scouts and general managers for interviews. This year's Combine has been pretty controversial, as there have been reports that team scouts and general managers asked several college athletes, including Colorado University tight end Nick Casa, if they are gay or if they date girls. Understandably so, players are perplexed by this questioning. The NFL has been made aware of this, and according to NFL spokesman Greg Aiello, the NFL is investigating the matter to find out specifically which teams ask college athletes questions about their sexual orientation. This incident is particularly interesting because the NFL has a no-discrimination rule in their collective bargaining agreement. Furthermore, while the NFL is a private entity and is not subject to federal employment law, state law and discriminatory behavior may preside over certain NFL teams. Thus, today's episode will discuss the NFL's rule on discrimination, what certain state law has to say on discriminatory behavior by an employer, and how it applies to the sexual orientation NFL Combine scandal. First, let's take a look at the governing body of law in this case, which is the NFL Collective Bargaining Agreement. Remember that the NFL CBA lays out the terms and conditions that both players and NFL teams must abide by. It's further important to state that the NFL CBA is a body of law that is agreed upon by the NFL players and the teams. In the NFL CBA, under Article 49 titled Player Security, there is a no discrimination clause which states the following. There will be no discrimination in any form against any player by the Management Council, any club, or by the NFLPA because of race, religion, national origin, sexual orientation, or activity or lack of activity on behalf of the NFLPA. So this clause does not only protect the player from being asked about their sexual orientation, but it protects a player from being asked whether they're Muslim or Christian, whether they're from a foreign country or from the USA, or whether they're white, black, or even Native American. By asking a player whether he is gay or straight based on the black and white letter of the CBA is discriminatory behavior according to the NFL. As mentioned previously, certain teams may be subject to discriminatory behavior under certain state employment laws. Again, we don't know which teams asked the NFL Combine attendees if the players were gay or straight. Yahoo Sports broke down which teams, as a matter of state law, are allowed to ask a player about their sexual orientation. Of the 30 NFL teams, the following teams are not allowed to ask players about their sexual orientation based on state law: the Baltimore Ravens, the Buffalo Bills, the Chicago Bears, the Denver Broncos, the Green Bay Packers, the Minnesota Vikings, the New England Patriots, the New York Giants, the New York Jets, the Oakland Raiders, the San Francisco 49ers, the San Diego Chargers, and the Seattle Seahawks. Thus, the states that ban this type of activity are Maryland, New York, Illinois, Colorado, Wisconsin, Minnesota, Massachusetts, California, and Washington. Let's take a look at some examples of state law that bans discriminatory behavior from employers. New York law on discriminatory behavior states the following: it shall be unlawful discriminatory practice for an employer or licensing agency because of an individual's age, race, creed, color, national origin, sexual orientation, military status, sex, disability, predisposing genetic characteristics, marital status, or domestic violence victim status, to refuse to hire or employ, or to bar or to discharge from employment such individual, or to discriminate against such individual in compensation or in terms, conditions, or privileges of employment. Meanwhile, over in California, their law on discriminatory behavior says the following: it is an unlawful employment practice unless based upon a bona fide occupational qualification or except where based upon applicable security regulations established by the United States or the state of California for an employer because of the race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, age, or sexual orientation of any person, to refuse to hire or employ the person, or to refuse to select the person for a training program leading to employment, or to bar or to discharge a person from employment or from a training program leading to employment, or to discriminate against the person in compensation or in terms, conditions, or privileges of employment. From these two examples, we see how stringent certain state laws are regarding employers asking prospective employees about their sexual orientation, race, religion, and other classifications. In the case of the NFL, if it is revealed that one of the aforementioned NFL teams had their scouts asking college athletes about whether they're gay or straight, they may be subject to litigation as per state law. The scouts would be effectively engaging in illegal practice and would be subject to some type of sanction. Nevertheless, we can't overlook the fact that the NFL is subject to CBA terms and conditions. Thus, asking college athletes about their sexual orientation is impermissible employment practice as per the CBA. The pending NFL investigation is expected to put an end to this situation and prevent scouts and teams from behaving in a discriminatory manner, whether the player is being questioned about their race, religion, national origin, or sexual orientation. That's the show. Leave all your comments down below, and be sure to visit Law and Batting Order at lawandbattingorder.com, as well as on Facebook and Twitter. Take care, guys.